Mr. Chair, I appreciate it.
All right, Senator Mitchell, you have item 3 up now, right?
I do. SB 176. Thank you very much. Members, SB 176 is a bill that will help protect minor witnesses of a crime from being re-victimized during the criminal proceeding process. Under current law, a minor victim of a violent or sex crime can testify via a closed circuit television. This allows the minor victim to testify without being subjected to being in the same room as the accused perpetrator, a person who may have caused physical or mental distress to the minor. SB 176 would expand upon law by protecting minor witnesses of a violent or sex crime, again allowing them to testify via closed circuit TV. The legislation was inspired by a recent court case from Fresno where a child of a father who was murdered in front of her was forced to take the witness stand face to face against the man who murdered her father. In fact, it was on the local news this weekend. That case was actually closed. Opposition has expressed concerns that expanding current code to allow for minor witnesses as well impinges on a defendant's right to confrontation and will make it impossible to adequately represent a defendant with child witnesses. Closed circuit television does still allow for a minor witness to be questioned and cross-examined, so that right is not waived. A courtroom should not be the place where a child is forced to face a defendant for which the child was a witness to a violent crime solely to draw on an emotional reaction from the child to play to the grand jury's sensitivities. With me today is someone who should be familiar to many of you, Melina Blake from the Californians for Safety and Justice, to testify in support of the bill, and I ask for your aye vote.
Thank you, Ms. Mitchell. Go ahead. You have 2 minutes. We'll have 2 witnesses, 2 minutes each.
Thank you very much. Good morning. My name is Melina Blake. I'm with Californians for Safety and Justice, and we are proud to be the sponsor of this bill. This bill came out of a case from our Crime Survivors for Safety and Justice network out of Fresno. And as the senator mentioned, it was a 7-year-old girl who was required to testify at her father's murder trial. The person who was ultimately convicted of the crime was a family friend, so it was an adult that she felt was a trustworthy person and now had to face in court. There was existing case law, but the district attorney didn't feel that it was clear enough to use it in this case. That case ultimately did settle, and the perpetrator was sentenced just this past week. But the mother and the daughter feel very strongly that they want to move forward with this bill to ensure that similar situations don't occur in the future. Unfortunately, the mother couldn't be here today. The little girl's getting her tonsils out. But she did want me to urge to the committee how important this is to her families and families like hers, and to urge your aye vote. I'm happy to answer any questions as well. Thank you.
Thank you very much. Go ahead, ma'am.
Good morning. Kim Lewis, representing the California Coalition for Youth, and we are a statewide advocacy organization representing a lot of disconnected and disenfranchised youth, and we feel like this will help prevent youth from re-experiencing the trauma of already the situation that they've encountered, and help mitigate that for the youth. Thank you.
Thank you very much. We'll now have witnesses who wish to come forward and state name, organization, and the fact that they support. Go ahead, ma'am.
Rebecca Gonzalez, National Association of Social Workers, California Chapter, in support.
On this bill, Marty Varanakar, on behalf of the California District Attorney Association, we're in support of this measure. Thank you.
There we go. All is not lost. All right. Now we will have witnesses who wish to speak in opposition to this bill. If you'd like to come forward and have a seat at the table.
Good morning, Madam Chair and members. Senator Mitchell. Khalif Asagai on behalf of the California Public Defenders Association. We remain opposed to this bill based on the fact that we do not believe that a child witness can be adequately cross-examined via closed-circuit television. Excuse me. Additionally, that the jury will not be able to pick up the small nuances of the child's testimony via closed-circuit television. In the particular case that brought forward this bill, the identity of the perpetrator was clear and known to the young lady. She knew him as a family friend, and there's no issue of identity. This bill will apply to everybody, including witnesses in cases where the identification of the perpetrator may not be clear. We believe that it's necessary for the jury to have the opportunity to see the emotion of the child in that circumstance when they're testifying against somebody whose life is potentially on the line, who may be an innocent person. Furthermore, we believe the veracity of the testimony can be better identified by the jury if that person is here in the actual courtroom. Thank you.
Okay, thank you very much. Don't go away. I'm going to have some questions for you. Any other witnesses in opposition to this bill? Okay, so then we'll bring it up here to the dais for discussion. Members, do you have any questions?
Move the bill. Second.
No questions on that side? Okay, so the bill has been moved and seconded. And I do have a question for you, though. So you said that you don't feel that a child can be adequately questioned in that particular type of closed-circuit environment. Can you explain to me
What I
you
should
mean
say
by
is that the presence of the child in the courtroom produces a certain type of energy and interaction between the witness and the jury, and that in order to properly cross-examine the child for the benefit of the jury, that their presence in the courtroom is going to be better and more meaningful than having them be there via closed-circuit television. And their actual right to confrontation is the literal confrontation of somebody in a courtroom having to make those claims in front of that person. And so we think that should be preserved for the right and the benefit of the defendant.
Okay, and you also said that there are certain nuances that just wouldn't be picked up in a closed-circuit situation. Can you explain what you mean by that? Because it's my understanding that though it's closed-circuit, the jury would see the testimony of this child, right?
Absolutely.
Just not there physically in the room, right?
Right.
So what nuances would be missed?
Well, I think there's a interaction that happens between people when they're in person and they can actually see each other versus when they're via closed circuit. If I was testifying here every week via closed circuit television, you wouldn't know me as well. You wouldn't pick up my energy, the little ticks that you might see.
I got your
before
energy.
you.
Don't worry. I picked it up.
Exactly, because I'm here. And so that's what we're trying to say, is just that the courtroom is a charged environment. The emotions are going to be different inside that room than via closed circuit television, and we believe the defendant should retain the right to cross-examine these individuals.
Okay, well, I appreciate that, and I would agree with you to a point, except when we're talking about children, and you suggest that the energy is different, that the witnesses sort of react to the jury and the people in the room. That's correct. And when you're a 7-year-old child, the energy you're going to be feeling is fear. And I don't know that it's helpful to the situation to have a 7-year-old, a 6-year-old, a 9-year-old, whatever, testifying in person and looking at the person who killed their father or who killed their mother or whatever the case may be. I don't think it adds anything of any value personally, and I know you feel differently, to have that child there. I think maybe it might change their testimony a little bit, and not in a good way. I appreciate your comments, as I always do, but I do support this bill. Senator Mitchell, I want to thank you on behalf of all these kids who are going to be put in this situation. That's very, very difficult for bringing this forward and having really a heart and a passion for this type of situation. I know you bring bills forward often that relate to this, protecting kids, protecting victims, and I do appreciate that. So with that, the bill has been moved and seconded. Would you like to close, Ms. Mitchell?
I would. Thank you very much. I would just further say that to remind committee members that current law allows for a minor victim of a violent crime to testify via closed circuit. One could argue a child who witnesses a violent crime is a victim also. And just the suggestion from the opposition is what we're trying to avoid, that we're trying to avoid having a minor played, if you will, through the courtroom process. The whole point of a witness, the whole point of their testimony is to bring forward facts and not to play on their emotions or their fear, having to look in the eye of an adult who committed a crime that they witnessed. So the whole point raised by the opposition is what we're trying to avoid by virtue of this bill. Again, through the closed circuit television process, it has worked for minor victims, and we believe it can work for minor witnesses as well without sacrificing the integrity of the judicial process or the integrity of the process of the person being prosecuted. And so with that, I ask for your aye vote.
All right, thank you very much. Madam Clerk, will you please take the roll?
Quirk, Melendez, Melendez, aye. Jones Sawyer, Jones Sawyer, aye. Lackey, Lackey, aye. Lopez, Lopez, aye. Lowe, Lowe, aye. Santiago, Santiago, aye.
Okay, your bill is out. We will hold it open for the chairman to add on and vote, obviously, but your bill is out. Congratulations.
Thank you very much, Madam Chair. Thank you, committee members.
Thank you. Okay, last but not least, we have item number 5, SB 230. Ms. Hancock, is she here? Where'd she go? Oh. She left. Okay, well, we will send someone to go get her and wait just a moment. Well, welcome back.
Thank you. As you know,
I feel like you just left and then you had to come back, right? Yeah, sorry about that. We timed that just so you'd have to do that. Senator Hancock, you are the last bill on the agenda for today. Would you like to make your opening statement?
yes, thank you very much, Madam Chair and committee members. SB 230 is a technical bill to simplify and clarify the parole system by ensuring that once the Board of Parole Hearings determines that an inmate is eligible, suitable, and safe for parole, and after the Board of Parole Hearings position has been reviewed and confirmed by the governor, the decision will be implemented and they will in fact be paroled. Currently, an inmate can be found suitable and safe for parole by the board, but still have their parole date delayed by a significant time, often by years. And this is because the current system of sentence enhancements can add time. It's actually a very complicated formula that can add time for additional charges, even ones of which the victim was never convicted or that the jury didn't include in the original sentence. So this bill creates steps to minimize that delay, remove duplication, and allow supposedly paroled inmates to actually be paroled. The bill does not change anything about how the Board of Parole Hearings decides who is or is not suitable. It does not change the governor's ability to uphold or deny the board's decisions. The governor still has to decide if each and every individual is worthy of parole, and it lets no one out early. It simply says that when parole is granted by the board and the governor agrees that the person is eligible and safe for parole, they will be paroled. It's a common sense bill. It will save a great deal of money for the people of California to spend on the other things they want and need, either in corrections or in the community, and I would respectfully ask for your aye vote. With me today is the public, well, two witnesses in support.
Thank you so much. We have you have two witnesses here, 2 minutes each. Go ahead.
Thank you. Senator Hancock, Madam Vice Chair members, Khalif Asagai on behalf of the California Public Defenders Association, we're in very strong support of this measure. The existing system of figuring out parole time with complicated calculations and matrices is broken and convoluted. It's possible for an inmate to get an enhancement that the district attorney already attempted and sometimes failed to secure at trial. An inmate can get an enhancement for issues that the jury did not confirm as finding a fact at trial, and they can even get an enhancement because the Board of Parole Hearings believes the inmate used a gun in the commission of a crime, even though the jury did not find that. An inmate can even get an enhancement for a charge that was later dropped. SB 230 restores truth in sentencing by simply stating that when an inmate is found suitable for parole, they get paroled if the governor agrees. It does not change any of the criteria for parole. It simply gets rid of the convoluted system of enhancements. We urge your aye vote.
All right. Thank you very much. Go ahead, ma'am.
Good morning. Milena Blake on behalf of Californians for Safety and Justice. We are in support of the bill. Recently, we have made great strides towards achieving the 3-judge panel requirements in our prison overcrowding case in Plata, meeting the 137.5 population cap a year early. However, that's very tenuous, and we need to ensure that we are continuing to make steps towards ensuring long-term compliance with that 3-judge panel. We believe that this bill does allow that to happen by paroling people that have been deemed safe to parole. So we urge your aye vote. Thank you.
All right. Thank you very much. Are there any other witnesses who wish to come forward and state their support of the bill? Name, organization, and support only, please.
Thank you. Jim Lindberg on behalf of the Friends Committee on Legislation of California. We're in support.
Thank you. Anyone else wish to come forward in support of this bill? All right. Thank you very much. Is there anyone here who wishes to testify in opposition to this bill? Going once, going twice. No opposition.
There is no
it's your lucky day. Okay, so then I will bring it up here to the dais for discussion.
I would like to move the bill.
You may do that, Mr. Jones Sawyer. And Ms. Lopez wants to second. Okay, is there any other discussion? No. Okay, so I'm a little torn about this bill, to be perfectly honest. It is an opposed recommendation for us, but I'm struggling a bit with the fact that the sentencing already took place and that parole board members then have an opportunity to say, well, we don't think that was enough, so we're going to add to it. I struggle with that a little bit. That being said, I'm going to lay off the bill today because I want to dig a little deeper and get some more answers to my questions, which I would assume you will help me with.
I would actually love to sit down with anybody on this committee. I've been finding out more about how the parole system works and the sentencing system. It's very interesting and rather complex.
I'm sure.
Yeah. So
it goes
certainly
much deeper than the few pages that I have in front of me, but I do have a little bit of concern with how this takes place. So for that reason, today I'm going to lay off of the bill and do a little more research. But since we have a motion and a second, Madam Secretary, would you please take the roll?
The motion is due pass to appropriations. Quirk, Melendez not voting. Jones Sawyer, Jones Sawyer, aye. Lackey, Lackey, no. Lopez, aye. Lowe, aye. Santiago.
It needs one more? Right. It needs one more vote. Or when our members return, I'm sure those votes will be added on. So it's on call right now. But thank you, Senator Hancock, for bringing this bill forward. I look forward to speaking with you. Thank you. All righty. That concludes our agenda for today. But we're not adjourning yet because we have votes that need to be added on. And, of course, we're waiting for the illustrious Chairman Quirk to come back. So we're on hold. Okay, we will do add-ons now while we're waiting for the chairman to come back, Madam Secretary.
Consent calendar, Assemblymember Lowe. Lowe, aye. Item 1, consent. Item 2, consent. Item 3, Quirk still missing. Item 4 has been dispensed with, 5-2. Item 5, Quirk. Santiago? Santiago, aye. Item 6 has been pulled. Item 7 has been dispensed with on consent. Item 8, consent. Item 9, SB 420, Huff. Lowe? Lowe, aye. Without objection. Item 10, SB 453, consent. Item 11, SB 456, block. Lowe? Lowe, aye. Item 12, SB 517, Monning, has been dispensed with. Item 13, SB 629, Mitchell, consent. Item 14, SB 651, Leyva, has been dispensed with, 7-0.
Everyone else can go since you've added on. I shall stay and hold down the fort.